Okay, we are sticking with the Delphi case today, and I feel this is Groundhog Day. I do. I feel that in true crime, we have the same arguments over and over, but with different cases. Recently, we talked about the Idaho case, and both Brian Kohberger's defence team and the prosecution in that case filing motions to the judge that they want cameras removing from the courtroom. I've made a video about this, and all the same arguments. Well, different arguments, but it's the same argument from my perspective, put it that way, have come up in the Delphi case. The defence for Richard Allen filed a motion to have cameras introduced into the courtroom. We haven't seen any of the court proceedings to date in the Delphi case, despite there being massive international public interest in this case. But the prosecution have filed, there's been another mini document dump. And yesterday I talked about the prosecution's response to this 136-page memorandum that Richard Allen's defence had released. Go and check that video out. I made a video about that yesterday, if you missed it. But along with the prosecution's response, there was also prosecutorial response to the defence wanting cameras in the courtroom. So Richard Allen's defence put a good argument together, right? That they wanted cameras in the court. They've got nothing to hide. They want everybody to see what goes on in the courtroom. And I wholeheartedly agree. I'm in the UK, right? And up until the year 2020, cameras were not allowed. Not still cameras, not video cameras, no cameras whatsoever were allowed in UK courts. An artist was, so an artist could go in there and draw people. But with the new change in law in 2020, it doesn't mean that we now get recorded trials. It doesn't mean that at all. It's always been my firm belief that cameras should be allowed. You can turn up at a court and you can watch the trial, as long as you can fit in the public gallery. There's limited seating, and they don't let you in if the public gallery's full. And many courtrooms throughout the UK don't have big public galleries, so you may or may not get in. But this day and age, with technology like video cameras, there's absolutely no excuse for trials not to be filmed. You want to watch a trial, you should be able to watch any trial. That's just my viewpoint, right? The change in 2020 was that cameras would be allowed at the discretion of the judge, and there are quite a few judges that have trialled this now, will allow the recording and in some cases televised sentencing. Not the victim impact statements and things like that, just the judge's sentence. And over on my channels recently, we watched the sentencing of Lucy Letby. A few months ago, we watched the sentencing of Thomas Cashman. It's a step in the right direction. But this situation of should cameras be allowed in courts comes up again and again and again. Because I follow a lot of trials in the US, nearly 70% of my audience is from the US. Some of the biggest trials ever are in the US. Some of the biggest cases ever are in the US. And the US system is way more transparent than that in the UK. It's easier to get documents, discovery, etc. in the US than it is in the UK. Many cases, all that documentation, apart from stuff that's sealed, often for perfectly acceptable reasons, you can just download whatever you want. And I think that's great. I think that should be the system here as well. That it's just a thing that happens, rather than you having to wrangle with this organisation and that organisation to get stuff. Transparency is a big deal. It's a big deal, right? Not only should justice be done, justice should be seen to be done, and be seen to be done by anybody who wants to view it. Just my view. Now, in the Delphi case, the prosecution have put a document together that we're going to read through in a moment or two. Concerned, very concerned about the prospect of having cameras in the courtroom. And the argumentation there is just as silly as that both the prosecution and the defence have put together for the case in Idaho, Brian Kohberger's case. So, snark alert, right? It's ridiculous. And if I get sarcastic, if I get a bit ranty, then you've had your fair warning. Look, some of the biggest trials in recent history have been televised. What about George Floyd? Do you remember him? And the trial of Derek Chauvin, the guy who was convicted of George Floyd's killing. Was there a case that in recent history has been more politically triggering, more politically charged than that one? No, I can't think of one. And that was televised without incident. Without incident. I mean, has there ever been a trial where convictions had to be overturned because cameras were in the court? Has there ever been a situation where cameras in the court have resulted in people being unduly victimised? No. I know that the situation in Indiana is one similar to the UK in that it's only very recently that the law has changed. So courts in Indiana are not familiar with having cameras in the court, but plenty of other states do. And just look at those states where trials are frequently recorded and televised as examples of good practice. Anyway, let's read through this document. So here it is, state's response to defendant's motion for broadcasting order. The defence saying, look, we've got nothing to hide. Potentially the prosecution have got stuff to hide because this argumentation is, in my opinion, pretty weak. Now comes the State of Indiana by Prosecuting Attorney Nicholas C. McClelland. Respectfully responds to the defendant's motion for broadcasting order. The state would, of course, defer to the court's discretion concerning this matter and trust that the court will rule in the best interests of justice. The best interests of justice are for people to see justice taking place, in my humble opinion. But it's not my choice. It's not my decision to make. It's Judge Frances Gould's. So I hope she makes the right decision for this case. Would notify the court that the state has serious concerns regarding the defendant's motion, blah, blah, blah. Okay, so September 13th, 2023, the defendant filed a motion for broadcasting to allow cameras in the courtroom for all future courtroom proceedings pursuant to Rule 217 of the Indiana Code for Judicial Conduct. That the defence is asking the court to broadcast both the trial and pre-trial proceedings in their entirety. Okay, good. First, the state would ask the court to consider that previously this court has expressed a concern about extrajudicial grandstanding, which lead to the issuance of the gag order by the court on the court so motion December 2nd, 2022, in response to the press release issued by the defence. So, extrajudicial grandstanding, I assume that means by the defence, and I would assume that the prosecutor, McClelland, thinks that this 136-page motion is another example of grandstanding, which in some ways it is, right? In some ways it is. But the gag order isn't the same argument. You know, stuff's being released to the public via certain documents. This very document, right? This is the kind of stuff that would be discussed in court. This would be the kind of stuff that would be discussed at some pre-trial hearing or other. The gag order is to stop either side going on camera to a media outlet and giving stuff away that no court would ever hear. It's a different argument. Okay, that the defence team has continued this extra judicial grandstanding throughout their motion, including the emergency motion to modify a safekeeping order April 5th, and more recently with their verified motion for immediate transfer of custody and the motion for Frank's hearing with attached memorandum in support, all filed on September 18th. Now, I don't think asking for Richard Allen to be moved from a prison where he shouldn't be anyway to a county jail. He's an innocent man. He's not convicted. Why should he be in a facility of corrections? He's an innocent man. Denied bond, accused, but he's innocent till proven guilty in a court of law. Should be in a county jail. Yeah, I can see how the motion for the Franks hearing is somewhat grandstandy. But again, irrelevant. That the broadcasting of pre-trial and trial proceedings create the same concerns, if not more, given that attorney is immune from libel proceedings for statements made in open court, are they? That's interesting. That's very interesting. So they're scared. They're scared of what the defence might say. But unless they apply for a completely closed court, the media are going to be there. So if the defence decide to take up, a really grandstandy position in one of the hearings moving forward, the media are still going to be there writing it down and tweeting about it, aren't they? If cameras were allowed in, then this so-called grandstanding could be analysed by the public, and you never know. The defence might come off pretty badly in the public eye for doing that. But that's not a good reason to not allow cameras in the court. The judge can always stop proceedings and tell the defence off if they go too far. The Defence Counsel continues to use inflammatory language in pleadings, including statements that are simply not true, and there's no reason to think they will not continue to use supercilious language in court designed as sound bites for recording on the national stage. For example, the language used by defence describing the condition under which Mr. Allen has been forced to endure are akin to that of a prisoner of war. Again, what are you scared of? What are you scared of? Are you scared of camera recording that? Well, it's all out there. It's all out there anyway. So allow cameras in the court and let's hear, with our own ears and our own eyes, let's see this as it unfolds. That the defence has filed its 136-page memorandum in support of the Franks hearing, in which only 13 pages refer to any allegations relevant to the question of a Franks inquiry. The remaining 90% of the memorandum outlines its fanciful defence for social media to devour. Look, a lot of people feel that way. In a way, I feel that way. Again, it's not an argument to not allow cameras in the court. All of this stuff is discussed regardless. Not an argument. Not an argument. That the defence has already moved for change of venue, citing prejudicial publicity, and if the court were to allow broadcasting of pre-trial hearings, that publicity would be pervasive, and as the defence notes, will be without boundaries given the worldwide interest in the proceedings. There's a worldwide interest in the proceedings, even though there's been no cameras in the court. Can you see all of that interest that there is on social media, in the mainstream media? The fact that cameras could be allowed in the courtroom will give everybody the full story, not just the sound bites that the media puts out that come from the scribbling down that reporters do in the courtroom. It will give people the full story, not just the soundbite. So that's counter-arguing what you're trying to say. That the state believes that the duty of managing the broadcast media that is imposed on the court may become distracting considering the number of media outlets that request to the broadcast, the fact that the judge is in an unfamiliar courtroom, the length and complexity of the case, the duty to protect jurors' identity, and the sensitive content that will be presented at pre-trial hearings. Look, that's ridiculous. I know that it's new for Indiana, but just look at the trials that have been televised. Juries are not filmed. Right? It's not that there's going to be a pile of cameras. There's generally one pool camera that all news stations share. So Court TV, for example, might be in charge of the cameras, and they might set up, say, 3 cameras, different angles, none of which films the jury coming in, sitting down, throughout the trial. None of it is filmed. None of the jury's involvement is filmed. None. When there's a minor giving evidence or there's sensitive information, the camera is moved away from the witness box or is moved away from the screen. Turn the mic off when there was a sidebar. Come on, it's not difficult. That's a ridiculous argument. That the state believes that these hurdles may have a negative impact on the participants in the proceedings and impair the dignity of the trial. No, it won't. There's so many examples of how to do this. The credibility of a certain test or the credibility of some investigators frequently comes up in trials. Why are you scared of that being televised? Which will allow the defence team to grandstand on camera about the imagined bad motives of the state actors. This is put on display in the defence's memorandum in support of the accused motion in the Franks hearing. Yeah, okay, whatever. But televising the court proceedings, again, will show the defence potentially in a bad light if they grandstand too much. It could go in your favour. The public opinion could sway in your favour. I think the public opinion overall is already on the side of the prosecution. I don't know. There's a lot of people who think that there's something in this 136 pages. I'm open-minded about it. But let's see it. Let's see all the evidence put forward. Let's see it with our own eyes. It gives the layout of the courtroom. The state is concerned that with the cameras in the courtroom, those cameras may broadcast the jurors. No, they won't. Witnesses who are minors. No, they won't. Attorney-client communications and materials. No. Now, that's one of the arguments that has been fashioned in Idaho. No. You position the cameras so they can't see the jury. You position the cameras that can be turned away if a minor is giving evidence, or turned away if there's sensitive evidence going to be presented, such as autopsy photos, and the mic's turned off during sidebars. It's not difficult. It's not difficult. That the state believes the defendant's statement that the jurisprudence in the state of Indiana will be scrutinised in a manner that is unusual and rare in Indiana courts because of the circumstances. Well, again, what are you scared of? All that's going to be reported anyway. What are you scared of? That the defendants claim that the Community Relations Committee of the Judicial Conference of Indiana favoured the Kohberger article favourably is false. The Kohberger article makes several recommendations to courts on how to build public trust and confidence, including expanding transparency, increasing social media presence, publishing summaries of court decisions directed to the general public audience, blah, blah, blah. A committee member mentioned the pilot program was highlighted in the article, not that the committee favourably considered the article. Okay. That cameras have never been allowed in the Carroll County Circuit Court during any proceedings, and the state is concerned about the case of this magnitude being the pilot case in which cameras are allowed. Well, some case is going to have to be the pilot case, the first case. Why not Judge Francis Gull be the spearheader of transparency? Why not this case? You could make the argument for any case moving forward. There has to be a first time. And given all of the good practice that is out there in other states, just look at those. The fact that you said before that the judge is in an unfamiliar courtroom, come on. That's giving the judge the intelligence of a 3-year-old to not be able to work with Court TV or whoever does the filming, to position the pool camera in a certain place where the jury can't be seen, where the camera can be just turned off or turned away if a minor or a particularly vulnerable witness is giving evidence. Come on. Not difficult. That the defence notes that the size of the courtroom lends itself to many onlookers, meaning that there is plenty of room for legacy press to attend and report the activities of the court, and in fact the press has widely, accurately and without incident covered the pre-trial proceedings. Well, you're making your own argument. The fact that the press have had no issue reporting, doing their writing and their tweeting, means that there's going to be no issue in having a camera in there, is there? No reason to believe that the media could not continue to effectively report to the public. Why should we, the public, believe what they're saying? We want to hear it with our own ears and see it with our own eyes. That having cameras in the courtroom makes it difficult to have separation of witnesses for any testimony that the witness plans to give, that the state is concerned that witnesses may inadvertently violate any separation of witness order due to the potential pervasiveness of media relating to this case, creating issues with the admissibility or reliability of their evidence. No, it won't. That's ridiculous. Has there ever been an issue in the past? Those things are decided by the judge and communicated to the camera people that certain things may not be filmed. That broadcasting the evidence out to the public allows for the potential of members of the public seeing gruesome images of the death of Tillington. No, it won't, because you just don't show the autopsy photos on camera. That allowing cameras in such a highly publicised and sensationalised case runs the risk of creating a circus atmosphere, both in person and online, where 15-second clips taken out of context can race around the world in seconds. Well, the whole thing will be out there. So instead of the sound bites that the media gives and the tweets that the media gives, which can so easily be taken out of context, you've got the potential for the entire thing to be analysed. So any 15-second clips that come out that's out of context can be quickly corrected. Yes, there are numpties who make sound bites out of things, but they also make sound bites or sight bites out of tweets, out of context. That the allegations that the fact that the families have voluntarily taken to social media, that's bad grammar, and other media outlets somehow abrogates their right to privacy is unfair. The family use those outlets to generate tips and clues. At the very most, you'd see the family members, maybe, at a distance. They've not got cameras trained on the public. Not interested in that. We're interested in the defendant, the witnesses, and then, to some extent, the judge. That the state does not agree with the defendant's theory that having cameras in the courtroom will reduce unpredictable behaviour from witnesses and other participants. Yeah, I don't buy that argument either. The state believes that having cameras in the courtroom will give participants in the courtroom a nationwide platform to further their own agenda, build their brand, promote whatever platform they want, and generally showboat instead of focus on the presenting evidence. Yeah, that's aimed at the defence, isn't it? And you're just scared. You're just scared of what the defence might say. But whatever the defence says, to build the brand, to make the career, could just as easily fall flat on its arse and be the breaker of someone's brand and someone's career. And that will happen regardless of whether cameras are there to witness it or whether reporters are there to tweet on it. That the pilot program in Indiana were conducted prior to the popularity of artificial intelligence that allows for the creation of deep fakes that intentionally and undetectably can alter the things that are said in court. Is this serious? Are you seriously arguing that people are going to make deep fakes of what's actually said in court? Because then what's actually said in court is actually there in the public domain, in the record. So any deep fakes that come out, people just go, that's fake. Look, that's what the real court said. Come on now. Come on now. Given the highly sensationalised nature of the coverage of this case, this is a concern the court should consider in exercising the discretion. Now, that's as wild as some of the claims that have been made by the defence in the 136-page memorandum. That's as wild as any claim they made. So, yeah, you're an absolute numpty. Nicholas C. McClellan, do your homework before you make such ridiculous claims in the public record. All right, guys, let me know what you think in the comments, and I'll see you in the next video.